and corporate law, representing businesses and individuals in state and federal trial and appellate courts and before arbitration tribunals. His employment cases include wage and hour discrimination, trade secret, and restrictive covenant disputes. He's an experienced litigator and also handles complex contract, partnership, and other business disputes. He's got a long list of honors and that are kind of too numerous to mention, but I will, if it's appropriate at the time, he'll get into that stuff. But and I'm sure what's not in here, which I'm sure he is now an expert in all things COVID, which is why he's here to talk to us. So for those of you, I think we've all been exposed to it in one way or the other in terms of what we can do and what we can't do. And, you know, talk about learning on the fly. This is something, obviously, you weren't around for the 1918 pandemic, were you, Andy?
Let me think for a second.
Because, and even
no.
if you were, the laws probably changed since then. But, you know, this is one of those things where everybody's learned on the fly. And
Yeah, you're right.
So expert is a relative term these days. It's the knowledge is, you know, 3 to 6 months old. But Andy's going to take us through what he knows, and we're going to encourage us to be as interactive as possible. But before you go, we're going to do, Alan and Holly are going to do a quick survey, and which will be interesting to see where everybody is at this point in time, 6 months into this. So Holly, Alan, take it away.
Yeah, I'll launch the first question. So this is the polling function of Zoom. So let's see if it happens.
Alan, I just put it up.
Okay, Holly's got it.
Does everybody see that?
Yep.
Yep.
Okay, so everybody just click. And we're gonna end the first question in a few seconds. We have about 30 participants. Okay, well, a little bit more. Everybody see that?
Yep.
Wow, look at that. People already opened. Okay. Okay, so Jeff, you got that? And Andy, see where we are?
Yep.
Okay, let's go to the second question.
Are you going to be showing the results? Or
Well, we're recording.
Everybody doesn't see him?
I'm going to share results.
thank you.
Can you see that?
Yeah, that's great. Thank you.
Okay, so Alan, you got it for the next question?
I'm going to clear that one.
Okay. Everybody see the next question?
No.
It's the same one.
Hang on, I think I got it. Here we go. Does everybody see that?
Yep.
Oh boy.
Wow, it's a majority.
That's a big one. Okay. Can you share the results, Alan, on that? Does everybody see the results now? No?
No.
Okay.
Let me try it, Holly.
You see them?
Yep.
Okay. 75% saying they're already hearing from employees who want to stay home. Okay.
All right. Next one. Last question.
Okay, so this is about going to work. What are you hearing?
These are not mutually exclusive.
That's true. Okay. Want to share, Alan, the last one, and then we'll get going?
Yeah, there's a couple people clicking still. Give it 5 more seconds.
Okay.
There you go. So just a couple housekeeping items. I'm going to mute everybody here before Andy goes to speak. So if you do have a question or something, you can type it in the chat room, and Andy will sort of guide us and make this as interactive as he wants to be. So right now I'm going to mute all, and then Andy, you can unmute yourself.
Okay, welcome to the world of COVID-19, everybody. As was stated, we are dealing with a situation that is changing every day with respect to laws, regulations, and guidelines. Candidly, none of us knew anything about this area. It's all popped up over the last few months. And it evolves every day. There are changes literally every day in terms of guidance and regulations and what Governor Cuomo says and what the federal government says and what it doesn't say. It's mind-boggling. So one of my recommendations is going to be from the get-go is don't guess. Don't punt. When you have a concern that doesn't appear to be addressed specifically anywhere, make inquiry, check it out. Don't punt, because there are a lot of issues that can unfortunately trigger a lot of lawsuits. Besides exposure, we've got the concern of lawsuits and statutory and governmental violations on top of that. So don't punt. Do your best to do your research, make inquiry, contact your counsel, and try to come up with the latest regulations and guidance always. Today, I want to focus on employee protections and special benefits that are available to employees during the COVID crisis. I want to initially focus on discrimination and disability-related issues and accommodations with respect to individuals who fall into those categories. Also, I want to touch on screening, testing, and confidentiality in the context of screening and testing. So let's first jump into the world of discrimination. And we're going to focus on people with disabilities or employees with medical conditions who may need accommodations. And by the way, let me know if you have questions along the way. Feel free to contact us at any point, but you can chime in now. So, generally speaking, I'm sure most of you know this, but employers must make reasonable accommodations for employees with disabilities, so those employees can perform the essential functions of their job, unless the accommodations that are requested would impose an undue hardship on the employer. What is an undue hardship, by the way? For the most part, it's money, it's expense. So that's something to keep in the back of your mind. If your employee asks for an accommodation that is way too costly, that may be deemed to be an undue accommodation that's being sought. In terms of disabilities and medical conditions, we're talking about disabilities and medical conditions that put employees at risk for COVID situations, for COVID illnesses, and people who fall into those categories are entitled to request reasonable accommodations. You don't have to volunteer them, by the way. The accommodations that might be requested, or they may be entitled to, rather, have to be requested. You don't have to guess. You don't have to be gratuitous about it. But if requested, you have to engage in what we call a dance. It's literally a dance. Somebody asks for an accommodation, you have to engage them and try to come up with some sort of mutually acceptable accommodation. And that's by reason of both federal law and state law. Now, the CDC, the infamous CDC, has identified certain medical conditions which are deemed to be placing individuals at a higher risk for a severe illness by way of COVID, and thus possibly entitled to accommodations. So what conditions are we talking about? Employees that have cancer, that have kidney disease, pulmonary disease, weakened immune systems from an organ transplant, obesity, serious heart conditions, sickle cell anemia, and certain types of diabetes. In fact, recently, I just had to deal with a situation where an employee had a kidney transplant. That person asked for an accommodation in the form of telecommuting because their immune system was compromised by reason of the transplant, the kidney transplant, and they were entitled to it under the law. That's just one example. There are other health conditions, by the way, that the CDC put out there that may be entitled to accommodations. We're talking about asthma, hypertension, dementia, pregnancy, not pregnancy in and of itself, but medical conditions that arise out of pregnancy. However, and this comes up all the time, what about employees that are just anxious, that don't want to come to work? We saw the polling that just came across. I'm afraid to come to work. I'm afraid to be at work. I'm afraid to commute to work. I want to stay home. I'm entitled to an accommodation under those circumstances. Well, unfortunately, those folks are not entitled to an accommodation. In other words, anxiety in and of itself, well, we are all anxious, let's face it. But generally speaking, anxiety about the COVID crisis does not entitle an employee to an accommodation. So the bottom line is you either show up or you're fired. And that's it. That's what it boils down to. I'm just trying to think of an example. I had this recently, a dietitian who works in a nursing home. She said, I don't want to go back there. I don't want to go in there for the obvious reasons. You know, everybody's getting sick. I don't want to get sick. I don't want to go in. Well, number one, how do you perform the essential functions of being a dietitian? And that's what a reasonable accommodation, and we'll talk about that in greater detail. But a reasonable accommodation means that you're trying to extend an accommodation to somebody so they can perform the essential functions of their job. How does a dietitian do that remote? And number two, just her general anxiety, unless it's clinically diagnosed as a disability by a psychiatrist, does not allow her or entitle her to an accommodation. So unfortunately, she had to go to work or face termination. And that's what the nursing home was telling her. Come in or you're out. She had to go in. An unfortunate situation. And I'm not blaming her. I'm not being critical or judgmental. That's just the law. What about employees that are over 65, by the way? They're deemed to be high risk for severe illness from COVID-19. We've read about it. We see it all the time. Are they entitled to accommodations just by reason of the fact that they're 65? I mean, I'm 32, so I don't have to worry about that. But by the way, my office is open and they're making us go to court, no less. The courts are open now too. But the bottom line is an employee who is 65 or older is not entitled to an accommodation by reason of that person's age, unfortunately, even though they're deemed to be in a high-risk group. Notwithstanding that, no accommodation is necessary. But when we talk about accommodations, what are we referring to? Well, the first thing that pops into mind was what the poll was indicating, teleworking, working remotely, working from home. That's the most popular accommodation that's being extended everywhere. But there are other accommodations. One accommodation could be PPE, protective equipment, such as gowns, masks, barriers, which would protect an employee if they're in an exposed environment. or in a crowded workspace. So that's another form of an accommodation. In addition to that, modifying work schedules can be an additional form of accommodation. Perhaps reducing the contact an employee has with coworkers so that it's not a crowded workplace, or perhaps allowing them to commute to work off hours, not during, quote, rush hour. And the trains are getting busier, so that's another form of accommodation. But the bottom line is, accommodations can be whatever works for both sides. The ideas are just endless. You just have to be creative and be willing to consider it. Just avoid shutting the door and saying, we don't extend accommodations at all, because then you're opening the door to a lawsuit. Now, there are instances where we have people who are working remote right now, and then the business reopens and they want to continue working remote. Are they automatically entitled to continue working remote merely because they were? The answer is no, they're not. Unless we're dealing with some specific disability situation or a significant medical condition that we must consider, merely because you were working remote before doesn't mean you're entitled to continue working remote in the future. And you have to also, again, take into consideration whether the essential functions of the job can be achieved by working remote. Some jobs, some instances require physical presence, like a stock boy, and that's being very simplistic, but more physical jobs would require on-site presence. There is another consideration, and I attended a seminar myself recently, and I never thought of this before, but if an employee is working from home and working from home quite effectively, and they possibly have a situation that would require an accommodation, some sort of potential disability or medical condition, the fact that the employee successfully functioned on a remote basis can be deemed to be a trial period to demonstrate that it can be done, that it can work. So you have to consider that as well. If the employee was doing it and can do it and has demonstrated an ability to do it and has either a disability or falls into one of the medical condition categories we discussed, then they may indeed be entitled to an accommodation of teleworking, and they've already demonstrated they can do it. So you should consider continuing it. Now, we have employees that are coming to work. What can we do? How do we protect ourselves and the other employees with people coming in? Well, there are screening devices, screening protocols that you can engage in. The EEOC has stated that employees who will be physically present in the workplace and not teleworking can be asked if they have symptoms or if they've had positive test results. And if the employees refuse to respond, they can be barred from the workplace. So you're permitted to ask those questions. And these are becoming very routine questions. Our own workplace does this on a routine basis. You have to check in and answer questions. But you can't ask, for example, if the employee has any family members who have been exposed, who have symptoms. By law, you're not permitted to ask about the family members of an employee, but there's a way around that. The way around that is you could ask them, you could ask employees while you're screening them if they have had contact with anyone, not a family member, with anyone who has been diagnosed with COVID or has COVID-related symptoms. That's a permissible question when you engage in your screening of employees coming to work. A related subject, testing. What kind of testing, if any, can we do? One of the popular measures, obviously, is taking temperature when people come to work. That's permissible. But you could also mandate that your employees go for COVID tests. Now, you may have to pay for the co-pays, but if you wish, you can mandate that employees go for COVID testing. But you can't insist that they go for antibody testing. That's against the law. Just
Andy,
the
we
way-
have a question I just wanted to ask you.
Shoot.
So right now, a lot of the schools closed down.
Yeah.
And so some of our employees are, have young children, they're in school. So is childcare considered a special accommodation? Like what happens if they say, if they did come to work and then all of a sudden they got to be home, they must be home with their kids?
Well, okay, that was something I was going to touch on, but I'll touch on it now. Let's get into it a little bit. There are two laws that apply to those situations. One's federal, one's state. Let's talk about the federal first. It's a mouthful. The Families First Coronavirus Response Act, which applies to employers with less than 500 employees. I'm sorry. That's what it applies to. And that law expires in December 31st, to be exact. For all we know, it'll be extended, but we don't know that yet. And briefly stated, it provides for two things, and we'll get to the kids in a sec. Number one, employees are entitled to 2 weeks of paid leave if they're sick by reason of COVID and they're quarantined and they're not working remotely, or if they have children. If they have children that are sick, or their schools are closed, or their childcare provider is closed by reason of COVID. So it has to be for COVID-related reasons. They're entitled, under those circumstances, to 2 weeks of sick leave at 2/3 their regular rate, subject to certain caps. And there's formulas for all this. And they can seek an additional 10 weeks of pay if they have to stay home and care for a child. And their jobs are protected under those circumstances. Now, we're talking about caring for a child if the school is closed, or if a child care provider is unavailable for COVID-related reasons. However, if an employer is faced with this circumstance and has 50 or less than 50 employees, the regulation provides. If you have less than 50 employees, you can seek an exemption from this. The employer can seek an exemption from this leave requirement if doing so would jeopardize the continued viability of the employer. What about hybrid situations? 2 days in school, 2 days out of school. Does the law apply? The answer, and I just did some research on this, the answer is yes. It automatically applies. The federal laws and the federal protections apply to these hybrid situations that we're reading about all the time. There's another law, too, that may have some application, and that's the New York State Paid Family Leave Law, which not only provides for guaranteed protections, job protections for the employee if the employee is ill, but provides for protections if the employee's the children are ill or a relative is ill by reason of COVID, or if the schools are closed by reason of a certain quarantine order or an isolation order. So if you have to stay home under those circumstances to take care of the kid and you cannot work remotely, now that applies to both the federal and the state law. If the employee is home and working remotely, none of these protections and benefits apply. But with the state law, there are payments that will be made to the employee, the job is protected, and they can stay home and take care of the kids under those circumstances, as long as they're not working remotely. So I hope that answers that question, Holly.
Yes, and I just got emailed, I just got chatted another question someone just asked, Andy.
Sure.
How does an employer protect itself if they opened up, so they opened up and an employee came in and now has been infected with COVID? You know, so they want to blame us and they want to sue us. They don't want to come back to work, and certainly all the other employees are getting riled up over it too. So and they don't want to come in. So how do we protect ourselves from that?
Okay, well, there are a whole bunch of things we're talking about there. So we have an employee that now you're talking about somebody that has COVID?
They came in. We opened up our office. They came in.
Right.
They're saying, and now they have gotten COVID.
They've gotten COVID. Okay. Well, okay. The first thing that you can do is make certain that before that person came into the office with COVID, that you had a whole bunch of protocols in place and the state mandates and the state guidance online about this. And the state has guidance and guidelines in terms of what protocol should be in place. The screening that we talked about, social distancing markers, mandating face masks, posting signage, reminding people about all these things. Maintain social distancing, wear your masks, do whatever's necessary to protect your employees by reason of being proactive. Have sanitation protocols in place. There's a whole bunch of things that you should be doing, including the screening. If I've mentioned it too many times, I'm sorry, but that's very important. And the reason I'm saying all this is if, God forbid, somebody then subsequently comes in and says, hey, I've got COVID, it's your fault. Well, there's two things that may happen. A, they could apply for workers' comp, but they may not be entitled to it because they have to prove that they got COVID from you, from the employer. Who the heck knows? Nobody knows. My wife got COVID recently. We have no idea how she got it, and I didn't get it. You just get it. God knows how people are getting it. So there's no way to necessarily establish that the employer is the source of it. But then part two of the question is, what do you do to protect yourself from even a bogus lawsuit, a baseless lawsuit? Because anybody can sue and make all kinds of crazy claims. So demonstrate to a court that you've got all of these protocols and safety measures in place already. We're doing everything that's possible. If you're doing everything that you're required to do under state law, federal law, pursuant to CDC guidelines, you're okay. You're protected, especially under these circumstances, because no one knows how the person contracted it. And by the way, when that person contracts it, the employer's allowed to make inquiry, ask questions about it, confirm that the person has COVID, and then can go to coworkers and say, hey, by the way, somebody that works in this area has COVID and you all should get tested. You all should check it out. Well, who was it? Who is it? Can't tell you. You're not allowed to tell anybody. And any records that you have pertaining to this have to be maintained in a confidential way out of the employee's personnel file. It has to be in a separate medical file. But you can tell the folks that you're in a situation where you may have been exposed, go get tested. Well, people aren't stupid. They may say, well, is it Johnny Doe or Mary Rowe? They may be right, but the employer cannot confirm the identity of the individual, even if that person has been identified by coworkers, by employees. You're not allowed to do it. So of critical concern pursuant to law is that you must not go out of your way to identify this person to everybody at the workplace. Limit the number of people who become aware of this person's identity. If you fail to do that, you could be in violation of various discrimination laws disability laws, EEOC guidelines. So you have to limit the number of people that can be aware of the identity of the person, the employee more specifically, who has COVID or is suspected of having COVID. Does that answer the question?
It does, and so what it's telling us is there could still be litigation, but you're in a better place to win the case if you make sure that you're doing the screening and you're doing the PPE and so we all have to do that. We all have to protect ourselves because any employee can sue at any time, but it's very hard to prove. And so what I think what we're hearing is we just have to follow the guidelines, period. So that if that does happen, we'll be able to win in court at that time. That's
right.
Yeah.
Yeah. And look, it's I think there's another question here. Holly, could you read that?
Yeah. If you have an employee who reports they have tested positive, should you conduct internal contact tracing? Should the employee ask the questions, investigate, and try to help do with that tracing? Should we get involved?
Yeah, the employer has an obligation to get involved. So first of all, if the employee says that I've tested positive or I suspect that I may be positive, I have all these symptoms, you should immediately bar them from the workplace. Go home. Go get tested. Okay, so they're out of the situation. And the employers, the management team, should immediately contact the local, state, or municipal health officials so they can engage in appropriate tracing, contact tracing. So the answer is yes, they're mandated to report it to the appropriate health authorities so they can do what has to be done. And the employer is under an obligation to engage in undertaking sanitary protocols, so to speak, cleaning up the area where that employee worked. Now, it's funny, you're not allowed to identify John Doe's name, but you're going to be standing at John Doe's workstation spraying away. So, what can I tell you? You're not saying or doing anything wrong, but they're all going to guess. But that's the way it is. You're obligated under those circumstances to try to mitigate and minimize what's going on with the virus. So attack it vigorously. Show that you not only have these protocols in place on a routine basis with bleach and whatever else you're doing around the workplace, but if something happens, you immediately approach that person's workstation and clean it up in effect.
But if that person wasn't socially distancing, is it the employer's obligation, Andy, to tell the 4 people around that person, now you have to stay home for 2 weeks? Is that something we have to do?
I would recommend that you tell those 4 people to go get tested because you may have been exposed. By who? Can't tell you. By the way, where's John Doe? He's home. Why? Can't tell you. I mean, it sounds absurd, but that's the circumstance that we're dealing with. However, you're right. Tell those people to go get tested. Absolutely. If there's any suspicions.
So we have another question, Andy. Does standard liability insurance or a D&O policy cover COVID-related employer practices issues? We all learned that business interruption insurance, for the most part, excluded the pandemic.
Workers' comp would apply. Workers' compensation would apply for the most part because this would be deemed to be an illness that occurred at the workplace by reason of the workplace. If it could be established that it arose from the workplace. We all read about the meat plants out west where it wasn't just one random employee becoming ill. You had a whole line of people, hundreds of people becoming ill. There, it wasn't that difficult to establish the relationship between the workplace and the exposure. But in most office situations, Holly, it would be very difficult. But putting that aside, Workers' compensation is a bar which prevents people from suing their employers under most circumstances if they suffer an injury or illness by reason of the workplace that arises out of their work. So for the most part, that's the protective device or policy of insurance that's available to employers should this situation arise. Workers' compensation. Make sure it's paid up to date.
April, do you want to unmute and give your question? April Bracco, you want to do that? I know you're on. April, there she goes.
Oh, yeah. I was just wondering if the employer is obligated to give time off, not including their employees' sick time, if they were exposed.
The answer is under both the federal and state laws, the employer would be obligated to allow those people to take off if they have contracted COVID-19. Under either law. Under the federal law, as I said, it's for a 2-week period. Under the state law, it's for a longer period, and the two laws can operate in tandem with one another. Does that answer your question, April?
Yeah, I just wanted to be certain that you couldn't make them use their sick time. It was above and beyond that.
The answer is, this is in addition to their sick time, but they are entitled to this regardless of their sick time. And so if this arises specifically, these protections go into operation, and if they exhaust the periods that are allowed under the federal and state law, then they would be permitted to use their sick time. By the way, something just came to mind. There was a recent change to the state law that said none of these protections are available to any employee who has traveled to a hotspot voluntarily. So if you send a staff member, an employee, on a work-related assignment to Texas, and they come back and they're sick, it's work-related. But if they went to Disney World on vacation and came back sick, and that's a hotspot, and we're talking about places with a positivity rate in excess of 10%, then that individual, in theory, is not entitled to any of these state protections and the payments that are afforded to them by reason of the state programs. And April, you should bear in mind that the payments that arise by way of the state program that we are talking about don't come out of your pocket, don't come out of the employer's pocket. These are part of programs that the employees have already paid into through payroll deductions. Usually it's by way of the disability deductions, insurance policy deductions that are made from the employee's payroll. And so it's a massive fund, and those funds pay for this family leave protection when the employee is ill by reason of a COVID-related illness or is required to stay home to attend to somebody with a COVID-related illness. None of those payments are coming out of the employer's pocketbook.
Mm-hmm. So it's on the honor system if the employee went to a hot spot on their own to take care of a sick mother, or, you know, if they traveled, it would be our honor system, really.
Well, you know what? As long as they voluntarily travel to a hotspot, then they are not eligible for any of these state payments.
Mhm.
It's unfortunate, but that's just the way it is. The state is basically saying, look, if you're going to take a chance, we're not paying for it. It's not coming out of this disability fund. We're
Mhm.
not going to reward you. And I don't mean to use the pejorative, but basically what they're saying is you're out of luck. So, you know, of course, the state's going to have to find out that this person has traveled to a hotspot. There's probably a questionnaire, you know, and obviously nobody should engage in perjury, but they have to first find out for that protection to be disallowed.
Andy, you know, we saw earlier in the poll that most of the companies here are not going to consider, you know, opening until 21. So offices are, and I put this in quotes, officially closed. And yet many of us are sending someone into the office, someone, to just do whatever, you know, water a plant, pick up the mail, get the FedEx, send something out. And in some cases, that employee doesn't want to do it, doesn't want to go. You know, what rights are there when they refuse to go into the office when we're officially closed, you know, when we want to get somebody in there?
The answer is they have no rights. They have to go water the plant.
Okay.
But if you're going to ask somebody to go into the office to do something, but it's a fair question, however, because let's take it beyond that. I know of a situation where an employee was permitted to work remote because of the kidney transplant situation. And he obviously had a compromised immune system. So the accommodation had been extended to the employee. He was working remote, but he had to go into the office. He had files and documents and all kinds of things that he needed. He couldn't perform the essential functions of his job without occasionally going into the office. So what do? How do you facilitate the needs of both parties, the employer and the employee? Well, again, let's be creative. Besides maintaining a very clean environment, hopefully, papers, documents, whatever that person needed were stacked up on their desk. And they came in at night when they were the only person present. So that person is not exposed, Holly. And the essential functions of the job are being performed by reason of this coordinated accommodation. So, you know, you have to be creative. You have to be thoughtful about it. In most instances, you can come up with something that works for everybody.
Mm-hmm. Jeff asked a good question. You know, obviously the rules continue to change. You just talked about how a rule was put in place, a law was put in place only until 12/31, and who knows, we're going to hear about it sometime in December to be extended. So how does an employer protect itself when, you know, they don't know what the rules are all the time and they change at a later date? So, you know, what we're doing now may work out, but 3 weeks from now, the rules could have been changed. Is there some way to keep ourselves updated?
It's tough. It really is tough. Number one, you could continue to look at the guidelines that are issued by the government authorities, but you've got all these competing authorities because the CDC says one thing, and I'm not getting into the politics of it, but it says one thing one day, and then it says something else the next day. Then the state says something else. You've got the governor's executive orders and the state health department. You know, it just goes on and on. Then you have the EEOC that comes out with guidance. You know, so my hair is getting grayer all the time because it's a real struggle to stay on top of it. So what we're doing is we're doing our best to stay on top of it. Contact your counsel. That's the best thing to do. Contact your counsel if you're not sure. You know, because it is of a evolving nature, and it's bound to change again. It's already changed. The state just passed a new New York State paid leave law. I don't. Is everybody aware of that? There's a
Tell
new,
us.
yeah. It goes into effect September 30th. That employees starting next year are entitled to 5 paid sick leaves, 5 paid days off for sick leave purposes, 40 hours. 40 hours for smaller employees. Employers, larger employers, it's I think 56 hours that the employee would be entitled to with respect to sick pay. So that has to be factored into all this too. That's another level of protection that's available to employees in the COVID crisis. So you've got the federal law, you've got the paid leave law, you've got the now New York State sick pay law, which is, I think, the first state in the United States to mandate that every employee is entitled to a minimum of 40 hours of paid sick leave.
New Jersey put it in place last year.
New Jersey has
Yeah,
it?
yeah.
Oh, okay.
Yeah.
New Jersey and you perfect together.
As long as it could also be you could also have, if you're already giving paid vacation, you can allocate that paid vacation to sick leave. But if you don't offer any paid vacation time, you have to offer, I believe it's 40 hours of sick.
Right. And you have to, you know, some of the recommendations, Jeff, is that this should be front loaded. So you have it right out there, because, you know, the debate that is going on now is, what if the employee innocently exhausts all of their time?
Right.
For valid reasons, vacation, whatever, then they get sick. You know, so what we're recommending is that it be front loaded, and you tell people, let's say you give them 20 days PTO. You say it's for any reason, including, and New York State is very specific, Jeff, in terms of how those 5 sick leave days are to be utilized. They can be utilized not only for your own sickness, but to attend to the needs of a sick relative. It goes on and on. The very, very specific requirements. So what you do is you put into your employment handbook the new guidance, and you say, look, we're giving you X number of days. You could use it for any reason whatsoever, including but not limited to your illness or the illness of others. And then you set forth what the state mandate provides in terms of how they can use these sick days. You also have to be prepared to document that this was made available. The employee can ask for a record of how much of that time they've utilized. They could ask for it in writing or orally. I mean, this just came out. So there are a lot of requirements with respect to that.
But just to clarify, the 2-week guaranteed paid at 2/3 rate sick leave is over and above that. So if it's COVID related, it doesn't matter whether you have sick time or if you used it all or vacation, whatever, that's over and above, and the employer has to give it to the employee.
100% correct. Right.
So
right.
if somebody has burned all their time and there's a COVID issue, that they're still going to be able to get paid at least 2/3 and use that time for that.
Right. Sure. So you have, but what the state is basically saying, you can consider all these different laws and join them together.
Right.
So in that situation, Jeff, that employee who has to stay home to attend to their children under those circumstances, and the employee gets 2/3 pay and is not working remotely because I'm taking care of my kids, I can't work remotely. They can get up to an additional 10 weeks at that 2/3 rate.
Right.
And then on top of that, they have these other programs that are available, the state programs, so to speak, the state laws and state protections.
And one of the other things, just for, I think for everybody to keep in mind, you correct if I'm wrong, is that if anybody kept their employees on the payroll and didn't work during the early stages of COVID, and we got PPP money, so that time counted towards that 10-week total. So as long as you were paying people not to work, that goes to, I believe that goes towards that total accrued 10 weeks of paid time that an employee is entitled to.
In the context of somebody who was staying home to attend to their children?
No, so in the early stages, the first couple months basically of the shutdown, we had a lot of people that weren't working at all in our factory.
Sure.
And our understanding is that if somebody needed that 10 weeks of additional, or the additional 10 weeks of paid time, that you can count the weeks that they were paid for not working towards that 10 weeks.
10 weeks I'm talking about that I was referring to was in the context of caring for children.
Correct. So same thing, yeah, that 10 weeks, that whatever you paid them for not to work initially or throughout this process can be applied to the total of 10 weeks.
Maybe. I'm not exactly
Yeah.
sure. I'd have to check with some of my brethren at work,
Yeah.
to be candid with you.
Okay.
I haven't been directly involved with the PPP program. We have a few fellows at our office that are exclusively working on that.
Right.
And that's a confusing nightmare in and of itself sometimes.
Right.
Hopefully that'll be extended, but we'll see.
Andy, I think you answered this. Somebody's asking, are the rules different for small companies that have 10 or few employees? And I think the answer is yes. You've got to just know the rules for smaller companies. But do they do 10 or less? You know,
I haven't seen that yet, Holly. The only time I've seen anything that addresses smaller companies was in the context of allowing an employee to stay home for those full 12 weeks by reason of the kids' schools being shut down or the child being ill. An employer with less than 50 employees can seek an exemption from that obligation to afford them the right to stay home for in effect 12 weeks because it threatens the continued viability of the company. I mean, let's say you have a shop of 5 people and I was dealing with this recently with an insurance broker. It's a small office, relatively speaking. Everybody wants to stay home. It's less than 50 employees. They want to stay home with their kids. And his response was, I'm going to close. Not everything can be accomplished remote. If it can be, that's something else. But it's a real problem. So he has an argument.
okay, we have about 5 minutes left. If somebody has other questions, to unmute, or if there's anything else, Andy, that you wanted to share.
Yeah, the only thing I want to share is that there are a lot of, I've spoken in a lot of generalities along the way because that's the nature of the beast under these circumstances. So it's a fluid situation. Be flexible, be vigilant, protect yourselves, do as much as possible to limit exposure to your employees, try to work with your employees. Forget about the legal implications. You want to maintain good morale. So, perhaps extend yourselves beyond what the law provides and be more concerned about productivity versus certain hours being achieved by the employees. The key is to maintain a good relationship with the employees, maintain good morale, and show them that you care. And in the long run, you'll probably get greater productivity from these folks if you do that. Let's face it, that's what it's about.
Jeff?
All right, so a lot of things to think about, and as we've all dealt with this, as you so ably noted, this is an ever-changing landscape, And I think the best advice we can all leave here with is just keep your eyes and ears open. And you know, this is a place where it pays to spend some money and make sure that you're getting the best advice you can. And that's what we do. We have an attorney that we use and keeps us as up to date as he can. And, you know, hopefully we're doing the right thing. So
Yeah, Jeff, look, let me say something else. And if you ask your lawyer something, there's nothing wrong with the lawyer saying to you at that moment, I don't know, but I'll check it out.
right,
I'll
right,
find out for you, because it's just too much to know.
right, right.
You know,
And
well,
Jeff's headquarters is in New Jersey, so that's very important too. Most of us are in New York. It's different state to state, obviously.
oh, sure, absolutely.
So Andy, thank you very much for your time.
My pleasure.
Appreciate you
My
sharing
pleasure.
your knowledge with us. And I'm sure if anybody is looking for some help in the New York area, Andy's available. I don't know if you have any time these days, or you got some open to listen, I assume. So appreciate your time, and very informative and helpful, and hope everybody else found it the same.
My pleasure. Nice meeting everybody, seriously.
Thank you, Andy.
Thanks, Andy.
Thanks, Andy. It was
care,
great. We
Thanks,
appreciate
Andy.
it.
Thank you all. Thank you. Take care.
Thank you.
Bye-bye.
Thanks very much.
Thanks, Andy.
Thank you.